Hey you guys, welcome back to my channel. Welcome back to Since Day One. Before we get into this video about R. Kelly's New York detention request, go ahead and like the video, comment your opinions down below, and if you're new, smash that subscribe button to take flight with us. New York detention request. A letter from federal prosecutors in Brooklyn was delivered to a U.S. District Court judge asking that R. Kelly be held without bail before he can be removed to the Eastern District of New York and tried for what prosecutors allege is a racketeering enterprise to traffic and abuse women and girls. It reads, United States versus Robert Sylvester Kelly. Dear Judge Donnelly, the government respectfully submits this letter in support of pretrial detention of the defendant Robert Sylvester Kelly. For the reasons set forth herein, the court should order that the defendant be detained pending his removal to the Eastern District of New York and trial because he cannot overcome the presumption that there is no combination of conditions that will reasonably assure his continued appearance in this case or protect the safety of the community were he to be released. As set forth below, the charges in this case are extremely serious. The defendant is charged as the leader of a racketeering enterprise, engaged in a pattern of racketeering activity spanning 2 decades involving the exploitation of children, coercing and transporting women and girls to engage in illegal activity, kidnapping, and forced labor. If convicted on all counts, the defendant faces the prospect of spending decades in prison. Given the strength of the evidence in the case and the substantial prison sentence that the defendant faces, the defendant poses a significant flight risk, as his past interactions with the criminal justice system have failed to deter the defendant from continuing to engage in serious criminal activity. The defendant is also a danger to the community. Finally, as set forth below, the defendant's release also presents a serious risk that he will attempt to obstruct justice and threaten and intimidate potential witnesses. Number 1, factual background. Bullet A, the Eastern District of New York indictment. On July 10, 2019, a grand jury in the Eastern District of New York returned a 5-count superseding indictment. The indictment charging the defendant with racketeering involving 11 racketeering acts. Count 1, 2 counts of Mann Act, transportation to engage in illegal activity. Counts 2 and 4 and 2 counts of Mann Act, coercion and enticement to engage in illegal activity. As charged by the grand jury for over 2 decades, the defendant was the leader of a racketeering enterprise. The enterprise comprised of individuals who served as managers, bodyguards, drivers, personal assistants, and runners for the defendant, as well as members of his entourage. Along with promoting the defendant's music and the R. Kelly brand, the enterprise recruited women and girls to engage in illegal activity with the defendant, often transporting people throughout the United States for this purpose. This activity was often filmed and photographed by the defendant, including explicit depictions of minors constituting child videos. As alleged in the indictment, the defendant promulgated numerous rules that many of his partners were required to follow, including that the women and girls were to call him daddy. They were not permitted to leave their rooms to eat or to visit the bathroom without receiving his permission. They were required to wear baggy clothing when not accompanying R. Kelly to an event, and they were directed to keep their heads down and not to look at other men. R. Kelly also isolated the women and girls from their friends and family and made them dependent on him for their financial well-being. The defendant also maintained his leadership and control of the enterprise by demanding absolute commitment from its members, not tolerating dissent, and obtaining sensitive information about members and associates of the enterprise in order to maintain control over them. The crimes charged in the indictment took place throughout the United States, including in New York, Connecticut, Illinois, and California. The racketeering acts and substantive crimes charged in the indictment relate to 5 different people identified in the indictment as Jane Doe number 1 through Jane Doe number 5. Detailed below is a proffer of certain facts related to the 5 identified people. The grand jury returned the original indictment on June 20th, 2019. The indictment adds a criminal forfeiture allegation to the original indictment. Jane Doe number 1. The defendant met Jane Doe number 1 in or about 1999 when she was 16 years old. After another member of the enterprise approached her at a fast food restaurant and informed her the defendant wished to speak with her. Thereafter, while Jane Doe number 1 was a minor under 18 years old, the defendant filmed their intercourse on multiple occasions, thereby creating child videos using materials that had been mailed, shipped, and transported in interstate and foreign commerce. Jane Doe number 2, in or about in between 2003 and 2004, Jane Doe number 3 met R. Kelly at a mall outside the state of Illinois when she was in her early 20s and working as a radio station intern. The defendant thereafter invited Jane Doe number 2 to travel to Chicago, Illinois, purportedly to conduct an interview of him. Following her arrival in Chicago, Jane Doe number 3 was directed to a recording studio. Once there, she was escorted to a bedroom within the studio by one of the defendant's associates who also took and searched her suitcase. Later, while in the room, another associate made a copy of Jane Doe number 2's driver's license, directed her to sign what she believed to be a non-disclosure agreement, and advised her not to talk to anyone and to keep her head down. Jane Doe number 3 ultimately spent approximately 3 days in the bedroom, which was locked without sustenance. After a member of the enterprise provided her with food and a drink, she became tired and dizzy. She woke up sometime thereafter to the defendant with her in the bedroom in circumstances that made clear he had assaulted her while she was unconscious. Jane Doe number 3. In or about May 2009, when Jane Doe number 3 was 16 years old and the defendant was in his early 40s, the defendant began a relationship with Jane Doe number 3 in violation of Illinois law, which ultimately lasted for a period of months. During this time period, on multiple occasions, the defendant produced explicit photographs and videos of Jane Doe number 3 engaging in intercourse and contact with the defendant and others at his direction. In the course of their relationship, the defendant also engaged in a scheme, plan, and pattern intended to cause Jane Doe number 3 to believe that if she did not perform certain acts on him and others at his direction, she or her family members would suffer serious harm. The defendant engaged in a pattern of both physical and psychological abuse when Jane Doe number 3 disobeyed his directives, including slapping, choking, and isolating her in rooms for days at a time with no access to food, which caused Jane Doe number 3 to believe such punishments would occur if she did not acquiesce and perform acts she did not want to perform. In addition, the defendant caused Jane Doe number 3 to write and sign letters and other documents containing false information that, if released, could cause reputational harm to both her and her close family members as an additional means to extort control over her. Jane Doe number 4. In or about 2015, Jane Doe number 4, a minor and aspiring music artist, met the defendant after attending one of his concerts. Thereafter, at the defendant's suggestion, Jane Doe number 4 began traveling on a consistent basis with the defendant while he was on tour. At the defendant's direction, purportedly to learn about the music business, including to various locations in Connecticut and California, while Jane Doe number 4 was under 18 years old. In July of 2015, while Jane Doe number 4 was a minor, the defendant persuaded, induced, and coerced her to travel to Connecticut to engage in activity with the defendant, in violation of the Connecticut law. In October of 2015, while Jane Doe number 4 was a minor, he persuaded, induced, and coerced Jane Doe number 4 to travel to California to engage in activity with the defendant, in violation of the California law. Jane Doe number 5. Jane Doe number 5 met the defendant following an R. Kelly concert that she attended when she was 19 years old, at which the time the defendant provided Jane Doe number 5 with his phone number. Thereafter, the two communicated by telephone. In May of 2017, the defendant directed Jane Doe number 5 to contact an assistant to arrange for travel to and accommodations in New York to attend an R. Kelly concert in Long Island, New York. Following the concert, Jane Doe number 5 returned to her hotel room. In the early morning hours, the defendant unexpectedly arrived at Jane Doe number 5's room and loudly announced his presence. Ultimately, at the singer's direction, the encounter became sexual in nature and the two engaged in intercourse. The defendant did not use a condom, Prior to the intercourse, the defendant did not divulge to Jane Doe number 5 that he had contracted an infectious venereal disease in violation of the New York law. Notably, during the encounter in the hotel room, the defendant told Jane Doe number 5 in sum and substance that she was really 15 or 16 years old. She could tell him, suggesting he would have preferred for Jane Doe number 5 to be younger. Thereafter, the defendant arranged for Jane Doe number 5 to travel to various locations throughout the United States to see him, including in January 2018 to Los Angeles, California. During this trip, Jane Doe number 5 went to a recording studio in Los Angeles to see the defendant. Once at the studio, Jane Doe number 5 waited for many hours in a room without sustenance for the defendant to arrive. After briefly seeing him, the defendant did not show up again until the following day. After he arrived the following day, the defendant took Jane Doe number 5 into a smaller area room and instructed Jane Doe number 5 to take off her clothing. Jane Doe number 5 noticed a gun in the room, which the defendant moved to a piece of furniture nearby. He then proceeded to ask Jane Doe number 5 a series of questions, warning her there would be consequences if she lied. Given the surrounding circumstances, Jane Doe number 5 believed she was not free to leave the room. Thereafter, the defendant directed Jane Doe number 5 to give him oral sex in the room. When agents executed a search warrant at the defendant's residence on July 11, 2019, they found a holster and ammunition. The defendant arranged for Jane Doe number 5 to travel a final time to see him in February of 2018 in New York City. While in New York, the defendant engaged in intercourse activity with Jane Doe number 5, again without divulging to her that he had contracted an infectious venereal disease in violation of New York law. Jane Doe number 5 stopped seeing the defendant following this trip and ultimately learned that she had contracted an infectious venereal disease during the course of her relationship with the defendant. Medical records confirmed that the defendant had an infectious venereal disease during the course of his sexual activity with Jane Doe number 5. On July 11, 2019, a grand jury in the Northern District of Illinois returned a 13-count indictment charging the defendant with producing and receiving child video and enticing minors to engage in criminal activity. The charges involved the defendant engaging in acts with 5 minors in the late 1990s and early 2000s, all of whom are different from the Jane Doe persons identified in the indictment, and recording some of the abuse on multiple videos. As a result, the defendant has been charged with federal crimes involving a total of 10 persons in 2 indictments. The Northern District of Illinois indictment also charges the defendant with conspiring to intimidate persons and conceal evidence in an effort to obstruct law enforcement, including with respect to an investigation in the 2000s that resulted in the defendant's 2008 trial in Cook County, Illinois on state child video charges, of which he was acquitted. Specifically, the Northern District of Illinois indictment charges that in 2001, the defendant and another individual began paying an acquaintance hundreds of thousands of dollars to collect the videos of child videos for the purpose of concealing and covering up their existence. When the acquaintance later planned to hold a news conference to publicly announce that he had recovered the videos, the defendant and others paid him approximately $170,000 in exchange for agreeing to cancel the event. The defendant and other individual also agreed to pay one of the minors and another person for their efforts to return the videos, but only after they took polygraph examination to confirm that they had returned all copies in their possession. The Bail Reform Act. Under the Bail Reform Act, U.S. Section Code 3141, federal courts are empowered to order a defendant's detention pending trial upon a determination that the defendant is either a danger to the community or a risk of flight. A finding of dangerousness must be supported by clear and convincing evidence. A finding of risk of flight must be supported by a preponderance of the evidence. Look, y'all, I am really trying here. Like, for real, this is a lot. In addition, a court may order detention if there is a serious risk that the defendant will attempt to obstruct justice or threaten, injure, or intimidate a prospective witness or juror. A finding of a risk of obstruction of justice must be supported by preponderance of the evidence. The Bail Reform Act lists 4 factors a court should consider in the detention analysis: the nature and circumstances of the crimes charged, the history and characteristics of the defendant, including the defendant's character and financial resources, the seriousness of the danger posed by the defendant's release, and the evidence of the defendant's guilt. Evidentiary rules do not apply at detention hearings, and the government is entitled to present evidence by way of proffer, among other means. In the pretrial context, few detention hearings involve live testimony or cross-examination. Most proceed on proffers. See United States versus LaFontaine. This is because bail hearings are typically informal affairs, not substitute for trial or discovery. Indeed, U.S. Sanction Code 3142 F2B expressly states that the federal rules of evidence do not apply at bail hearings. Thus, courts often base detention decision on hearsay evidence. Where a judicial officer concludes after a hearing that no condition or combination of conditions will reasonably assure the appearance of the person as required in the safety of any other person in the community, such judicial officer shall order the detention of the person before the trial. Additionally, whereas here there is probable cause to believe that the defendant committed offenses involving minor people under 18 U.S.C. 2242, 2251, and 2423, it shall be presumed, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required in the safety of the community. Indeed, the presence of an indictment returned by a duly constituted grand jury conclusively establishes the existence of probable cause for the purpose of triggering the rebutable presumption set forth in. Elaborate bail packages are insufficient to protect the community against dangerous defendants. The Second Circuit repeatedly has rejected elaborate bail packages for dangerous defendants. If you see Farinati, you can see that they rejected a $1 million bail package secured by real property. If you see the United States versus Orena, they rejected a $3 million bail package secured with real property, home detention, restricted visitation, and telephone calls, and electronic monitoring. The United States versus Colombo, rejecting $500,000 bail package secured by real property. The Second Circuit has viewed home detention and electronic monitoring as insufficient to protect the community against dangerous individuals. In United States versus Milan, the Second Circuit held that home detention and electronic monitoring at best elaborately replicate a detention facility without the confidence of security such a facility instills. If the government does not provide staff to monitor compliance extensively, protection of the community will be left largely to the word of the defendants that they will obey the conditions. Citations and internal quotations admitted, see also Orena. Electronic surveillance systems can be circumvented by the wonders of science and sophisticated electronic technology. Internal quotation marks and citations omitted. Similarly, courts in the Eastern District of New York have denied dangerous defendants bail in recognition of the Second Circuit's dim view of the effectiveness of home detention and electronic monitoring. The protection of the community provided by the proposed home detention remains inferior to that provided by confinement in a detention facility. Rejecting bail because the Second Circuit appears to be saying to us that in this case of dangerous defendants, the Bail Reform Act does not contemplate the type of conditions suggested by the court, including home confinement and electronic monitoring. And that, even if it did, the conditions would not protect the public or the community, given the ease with which many of them may be circumvented. As set forth below, each of the factors demonstrates by clear and convincing evidence that the defendant is a danger to the community, and by a preponderance of the evidence that the defendant's release poses both a risk of flight and a risk of obstruction of justice. The defendant cannot overcome the statutory presumption in favor of detention in this case and should be detained pending trial. The nature and circumstances of the charged crimes as set forth above, the defendant is charged with serious crimes, including leading a racketeering enterprise that he created and used for decades to abuse and exploit women and girls for his own gratification, including through the use of kidnapping and forced labor. The pattern of racketeering activity charged includes the defendant's commission of 11 predicate acts against 5 different persons over 2 decades. Moreover, his status as the leader of the enterprise cannot be overstated and accentuates the already serious nature of the criminal conduct at issue. The enterprise and the defendant's status within it allowed the defendant to serially engage in criminal conduct with impunity, including against minor victims. The seriousness of the charged crimes and the attendant risk of flight is also reflected in the penalties that defendant faces, which include up to 20 years imprisonment on count 1, up to 20 years imprisonment of each of the counts 3 and 5, and 10 years imprisonment on each of counts 2 and 4. The history and characteristics of the defendant and seriousness of the danger posed by the defendant's release and the While the defendant has no criminal convictions, he has been charged with offenses including children in the past and is currently charged in Cook County, Illinois with various offenses involving misconduct. Moreover, as alleged in the Northern District of Illinois indictment, the defendant's acquittal on state charges involving child exploitation in 2008 may well have been the result of his own obstructive conduct, which included persuading multiple individuals to testify falsely before a Cook County grand jury. Emboldened by his fame and the lack of any real consequences for his conduct for so long, the defendant repeatedly and flagrantly used his resources and the enterprise at his disposal to continue committing serious crimes involving both minor and adult people. In addition, as set forth above, the defendant's conduct with respect to several of the Jane Doe victims demonstrates a willingness to intimidate potential witnesses to avoid criminal liability. For example, the defendant caused Jane Doe number 3 to write and sign documents containing false information that, if released, could cause reputational harm to both her and her family members. Similarly, following a civil lawsuit filed on behalf of Jane Doe number 5 against the defendant, a lawyer for Jane Doe number 5 received a typewritten letter in 2008. Oh my God, y'all, I don't think R. Kelly is ever gonna get out. He don't need to. This is his fault. He brought this all on himself, and thank the Lord this is the last page, y'all. Purportedly signed by the defendant, enclosed with the letter were 2 pieces of paper that contained images and typewritten text. Among the images were photographs of Jane Doe number 5 that had been apparently cropped to not disclose certain body parts. Beneath those photos was text including, "I assure you this would not be considered a Sunday go-to meeting dress." The next 2 pictures have been cropped for the sake of not exposing her extremities to the world yet. Based on the content of the letter and photographs, it is reasonable to conclude that the letter was sent at the defendant's direction, advising Jane Doe number 5 of his intent to maintain compromising photographs of her in an attempt to convince Jane Doe number 5 to abandon her lawsuit. This type of conduct is strong evidence that the defendant or members of his enterprise is likely to attempt witness tampering or other obstructive conduct if released. A factor which is also relevant to an assessment of the seriousness of danger posed by the defendant's release. The strength of the evidence. The evidence of the defendant's guilt of the crimes charged in the indictment is strong. The government will prove the charged crimes at trial through, among other evidence, the testimony of victims and other witnesses, including insider witnesses previously employed by the enterprise, medical records, phone records, text messages, cell site records, photographs, and other documentary evidence. Moreover, the witness testimony at trial will reveal a distinctive pattern and modus operandi, including from witnesses victimized by the defendant at different times who do not know each other, further buttressing the strength of the evidence against the defendant. The government's evidence is therefore exceedingly strong and clearly favors detention. The conclusion is, for the foregoing reasons, the government respectfully submits that the defendant should be detained pending his removal to the Eastern District of New York in trial. R. Kelly is never getting out. Ever. Ever, ever, ever. He gonna be making music for y'all supporters in jail. How about them apples? I love you guys. I'll see you in the next video. Don't have you here with me.